Welcome to Judge Echo, where we uncover the most shocking legal battles currently sweeping the USA. Subscribe Judge Echo for daily courtroom
The
update.
first allegation that accuses my client of a first-degree felony is from a person who was allegedly 13 or 14 or 14 or 15 at the time that it occurred. And it makes a big difference in regards to my client, because if she was 14, my client was 17, would have been a juvenile. Or if she was 15, he would have been 18 and would not have been in the state. He would have been in college in Virginia. So what I'm saying is that those first 12 counts really don't have any specificity as in regards to, and I've asked the prosecutor, she said she was going to kind of connect the dots for me for who the alleged victims go with what counts. But that first count is kind of bothersome. On top of that, allegedly there was an FBI complaint that was made by that person in count one. And there was a report taken by the FBI that I asked prosecutor. She said she doesn't have in her possession, but I brought it to her attention today in court that if there is an FBI report, that I would like a copy of it. Obviously, we deserve to have a copy of it if it was actually taken. There would be a report number by the FBI. There would be an interviewer. There would be a statement. There would be a report filed, and obviously, we would like to have a copy of that if it exists.
Well, okay, if I can just stop you there, and
Yes, sir.
I'll let you go on, but have you made attempts to obtain that report from the FBI?
I have
It
not.
exists.
I have just found out today, Your Honor. Just found out today. I just found out today. I also found out that his phone that was confiscated has some exculpatory evidence on it that's been seized. My understanding, and from reading all these reports and stuff, and I'm just not to be disrespectful to the author of the reports, but it's really all over the place. It's not a very good written report. There's things that are just all over the place. But one of the problems that I'm seeing in regard to that, judges, there are things that have been either just overwritten or not in there, the detail and whatnot. I'm not faulting because there's a lot of different people that are allegedly involved in this, but just trying to get through the different aspects of the report and who goes with what. It's all clustered in, and trying to figure out what charge goes with what person makes it very difficult. Even on just the 12, now we got 33 counts to contend with, to try to figure out what goes with who and the timelines and whether we're going to have alibis and all that kind of stuff. And there's just the times, dates, and things aren't there. The other thing that is that we're looking at is that they've sent out subpoenas to all these different places, the Snapchat, Yahoo, Gmail, all these different things to try to get all this alleged evidence that they are talking about that was sent back and forth. Because we're talking about computer crimes that have video, audio, text messages, emails, all that. We don't have any of that in our possession. I don't know if they don't have anything, but in reading the reports, I'm not getting that they have any evidence of any of these allegations other than just an oral made statement from an alleged victim to the cop saying, yeah, this happened. I don't know when. It was, I was 15 or 16. It happened quite a few years ago. And that's what we're contending with. We, as a defense, have to be put on notice of time and dates, places to be able to create a defense. It puts us at a very unfair advantage without having any of this information other than, for better lack of word salad in a report that doesn't give us any of the details of when these events, where they occurred, how they occurred, or any of that kind of stuff. Just an allegation that these things were done, and then they were done through a text message, through an email, but yet we don't have a text message, we don't have an email, we don't have a video. All these things that have been alleged are not being produced, or they don't have them in their possession. So what we really have is we just have people that have gotten together, that have made these arguments, and have made statements and allegations that the prosecutor has filed charges on, and we're not on notice of any of this stuff. And I think that, for purposes of going forward in this case, I mean, I'm happy to go forward. I'll do whatever the court wants me to do. But and if we do a preliminary examination, obviously, if they're going to put their victims on the stand, I'm going to cross-examine them, and they're going to take a while each one that they put on there. I'm counting at least 7 or 8 people, possibly, maybe more. I'm not sure how many are there. Notwithstanding the fact that I think that these charges are not related. Some of them are not related at all, and they need to be severed out. They're not. You can't just lump all this into one case and say, you're going to go to trial in one large conglomerate case. That's not the way these things, from what I'm reading, happen at different places, different times, different, allegedly, and didn't happen at the same time.
But so, at least as I understand it, these are, and certainly I'll let the people speak for themselves, but these are tied together really by your client's position vis-a-vis the.
I don't know until we get to the preliminary examination.
Well, right. I mean, but at least, I mean, you're telling me that, and certainly that can be true in certain circumstances, but.
Well, just for an example, Your Honor, count 1 is from 13 or 14 years ago. Some of these other counts are from from 2019, 5 years ago. So obviously it's two different times, places, and dates. I mean, it's not.
Well, right. I see what you're saying, but if I take it out of the context of what may be this case, if I had an educator or a teacher and they've been employed, say, at a school over, say, a 15-year period, but may have been engaging in similar conduct throughout their employment, that can be one case if that's what's happening. Now, again, I'm not saying that I know that that's what's happened in this case, but that is, at least as I'm to understand what was really occurring, is that that's what frames this as one thing.
Right. And again, if we go through a preliminary examination, the court finds that these are relatively relevant in that aspect, and then that would obviously be the court's decision to do that. I'm saying that from what I've read and what I'm seeing, I think that there is going to be severability on some of this stuff, maybe not all of it, but some of it. And, obviously that's going to be up to the court to make that determination. Obviously, whatever gets bound over, if anything gets bound over, I obviously would make that same argument to the circuit court judge if I had to, because I don't think that they are going to be relevant in that aspect. Some of these involve boys, some involve girls, and
yeah, but I don't know that the gender of a potential victim is going to be a basis upon which to sever these counts. But certainly you can make whatever argument you make, but as I understand, there is a certain element that ties them. And I think that being as I'm to understand it, and again, I'm not saying any of these as though I necessarily know, but at least what's been represented, because I was sworn out the counts 12 through 33 when they were sworn out. What tied it together, at least in the court's mind, was your client's position vis-a-vis these individuals. So, and that's all that I can say. I don't know that to be true. I mean, certainly, but that's what I understand.
And I understand, Your Honor, what you're saying, but again, I'm saying, if the allegations are 17 or 25, I mean, I certainly think that the circumstances are totally different between those cases. So that would be our position. I mean, obviously, I would need to do a little research, and now that I've got more counts to have to get through, it's going to be up to the court. I mean, again, I would say if we're going to go from here to the preliminary examination next, that it's...
Well, counsel, the way that this court has functioned, particularly with regard to PCCs, and that's the stage we're at now, to getting to preliminary examination, I want to make sure that each side has what discovery is going to be necessary to go forth. So I don't, unless I have to, I'm not really in the position and don't like to just push people to preliminary examination if you don't have anything or have everything, because, you know, at least in this court's opinion, it makes it a meaningless process. But some of what you brought up, I get, but I don't, you know, I'm never sure what's there either. I mean, the exam were mine, then I'd have to sort all of that out. But Ms. Reiser has all the, I mean, let's start with, well, maybe the hardest one, but the easiest one. The forensics on the phone, that takes time. And I'm presuming, given the timing of everything, that the people don't have all of the forensics from the phone.
That's correct, Jenna. There were several search warrants executed and electronic seized from the vehicle that the defendant was in, as well as the residence and the church office. So those items are being examined and they are not complete.
Got it. Okay.
But also I should say with caution, as in many of these cases, if it's password protected, it will take us some time to get into them. So if there's a phone or a computer device that has a password to it, and it may take some time, up to months, up to a year to break that.
And so then the question becomes, counsel, I think in that regard, so that you can be aware of what the court's position is and what the court's prior position has been. If there's a device that you believe has exculpatory evidence for your client, but the authorities are having difficulty getting into that device because of the password protection, then I'm going to let them do their work. If your client wishes to then give over the password so they can get in to expedite that process, then they're free to do that. So just so that you're aware of where this court has landed previously.
Yes, sir.
Regarding that. So, well, what it sounds like to me is that you're in a position, particularly now with these last counts and the 33 being there, attaching, and just so that I if I'm hearing you correctly, attaching individuals with particular allegations in the complaint.
I would like to know. I mean, I understand that they're minors, but I think that the prosecutor has a duty to at least say this, we're pinning this minor to count 12 and 13 or 14, 15, 16, to at least, so I know what I'm looking at for dates, times, places, or whatever. I mean, I could certainly file a motion for a statement of particulars if I needed to. I have no problem, whipping out a 5-minute motion and sending it in to be heard. But again, these are cordial things that the prosecutor should be willing to give to us without having to fight for them.
Well, sometimes funny when defense counsel comes in, because I don't know if it's a fight. Has it been asked for?
Yes.
All right.
I asked her today. So,
well, okay, but if you ask for it today, what was the response? No?
No, I think that she will be. I'm just putting it on the record, Your Honor, because I have asked for it today. I mean, obviously, my client's incarcerated, and this case is already, over a month old at this point, month and a half or whatever it is. I mean, he's sitting in jail on a very high bond, and obviously, we're waiting on discovery from them to make a determination of I mean, a lot of what they give me is how it determines what I'm going to do. I mean, I can't guess what I'm going to do. I need to have some.
I get that, counsel, but if you're just seeking to put this on the record, okay, fine. I mean, then there's not a response that I guess is going to be necessary from the court. I mean, if you ask for things today and their response were anything that you asked for, let me ask this question. Was the response, no, I'm not going to give that?
No, absolutely not,
Okay.
Judge. But I'm telling you, that was before she didn't know I didn't have the 33, because it got sent to the wrong email. So that's why I don't have the 33 count information. So I didn't get it sent to me. No fault of theirs. They sent it to the wrong email.
That's right.
And so I was unaware when I walked in here. I thought I was still dealing with counts 1 through 12. I had no idea I had count 1 through 33 until the court brought it to my attention. And I was like, oh, that's a new one on me. So I had spoken to her before that. So I'm hoping that it will cover all the counts, what I asked for. And I know that it might be one of those type of things where she's saying, well, these are minors and I'm not going to, I don't have to put it in the charging document, but, I would like to have that information so I can at least, talk to my client, see what those dates and times cover.
Okay. So what it seems to me is that there's been no request that's been turned down. And
None of this.
Miss Reiser, my understanding is that everything that the people have at this point has been turned over.
Correct, Your Honor. I did indicate to counsel today that I would send him the names associated with each count. Now, I will indicate for the record, count 6, 7, 8, 9, 10 have listed victims. Those victims are all listed in the counts, as is count 1. Criminal sexual conduct in the first degree relationship, 15, 16, 17, and 13, 14, 15, 16, and 17. I've sent him the name that victim is associated with. It's not written in the complaint because the victim is a minor. And that's also supported by all the discovery that's been sent to him by my office, by our discovery clerk. So all of the information supporting that, the multiple penetrations of the victim for the CSE 1 counts are in the discovery that have been provided. And I thought, and correct me if I'm wrong, but at the last date, I indicated to counsel in the court that there were more victims coming forward and I would have this amended complaint done and ready to go by today's date, which I did do. So this should not.
Well, the last part of that, I don't specifically recall. I do recall you saying that there were additional victims and then presumably additional charges. So I do specifically recall that.
I have shared with counsel the names of victims that I have associated with each count that I would intend to show at probable cause that victim is associated with that count. In some of the charges, the child sexually abusive activity, they persuade, induce, entice, coerce under the age of 18 to engage in a child sexually abusive activity. It doesn't call for a victim's name. It calls for a child under the age of 18. So I have charged one of those counts for each victim that he solicited them under the age of 18 to send images and videos of them masturbating to him. So there's one for each victim associated with each count. And all of this information in the discovery, each victim, each location, and it does occur from 2014 through 2024. So when counsel's ready, I think the best thing to do is to have a preliminary exam. I don't know when the electronics will be done. He's advised that there's exculpatory information on one of the electronics, but if we can't get into it, I won't until we can get into it. He's requested a FBI report on page 11 of 17 of the troopers, what I believe to be a well-written report, indicates that he had contact from other agencies on the morning of 10/17/2024. Special Special Agent Adam Christensen of the FBI Detroit contacted me about a tip they received from Holly on 10/7/2024. And so we'll obtain that from the FBI if we can. We don't have it in the discovery now, but if there is a report, I'll obtain it, and we'll forward it.
So just so that I'm clear, you're going to provide to him the names associated with each count.
I already have sent him an email with the names that I intend
Okay.
to associate with each count.
And that was sent
That was just emailed. You should receive it.
today.
Yes.
Okay, so everything's happening today. All right, that's fine. So that would take care of that issue. And then it would also seem to me, counsel, to take care of the issue regarding potentially at least some of the timing and other things, because that can then be tied up into reports, right?
Yes, sir. Hopefully.
All right, so what do I want to, what do you guys want to do today? Because the way we keep standing here, it's going to be Thanksgiving.
Can I have a second to confer with my client real quick?
Certainly. Counsel, yeah, you might want to step back from, or not. All right. Counsel.
Yes, sir. So if we had one more PCC just to go through all this stuff to make sure that we have everything that we need to be ready, could we do that? If not, we
Yeah, I mean,
I have no
counsel, if you ask for an adjourned PCC, I know there are other courts around the state that they won't do it and whatever. I will adjourn the PCC. It behooves no one if the parties aren't ready to go. So if you need an adjourned PCC, I don't have a problem doing that. It's just a matter of what time you're looking at to make sure you can get through everything. And so.
I think that, in light of the new information that we have, just so I can get it to my client, let him go through it, get some notes. I'm going to need some explanations, not that it's a problem, but I'm on the other side of the state, so I have to make my way over here to do that with him. So if I could just get a little time to get him that information in the new emails that were sent today, and I think maybe a couple weeks out.
Tell me when you want me to set it. I'm here I'm here today on Tuesday. I'm pretty much here every Thursday. The only Thursday, well, I know I'm here every Thursday because I see you every Thursday.
I know, you're so lucky.
But then, so every Thursday, and then during the holidays, I have dockets like I have today where they're split in two because prelims are typically on Tuesdays. So, but I can give you however many weeks out that you need, counsel.
Judge, I actually really like this time because it gives me time to meet with my client beforehand and do it in the afternoon, plus my drive over here. So,
I mean, we can give you an afternoon time. That's not a problem, but I just need to get a date.
Tuesday or Thursdays?
Well, no, just Thursdays.
Just Thursday.
The only Tuesday that will, no, that's a Tuesday. I have 4 Tuesdays, all Thursday.
All Thursday for PCCs.
Now, from here.
From here until out, yeah.
Could we do
Any Thursday.
we do the 19th, Your Honor?
Absolutely. People have any problem with that day?
No.
All right.
So it'll be 2:00 again, Judge?
Well, here's what I do. Probable cause conference will be adjourned to December 19th, 2024. I set it at 9 a.m. What will happen is you will get a sheet that will set it at a later time. So typically you would be in the afternoon.
Okay.
Okay. If there are motions filed, our process is if there are motions filed that have to be heard, then that's going to get kicked to a 3 o'clock block. And then everything is heard at 3 o'clock, no matter what time you were set throughout the day.
Okay. So if I'm hearing you right, so if this gets set for 9 o'clock on the 19th, we'll get bumped till afternoon anyway?
You're probably going to be in the afternoon. It depends on how many I have. I typically do not have under 100 that I have to do. So private counsel typically goes later in the day on a regular basis, so that because of scheduling.
Very good, Your Honor. Appreciate it.
Okay, all right. So that's the way it works. And if there becomes a difficulty, you can always contact my office and we will try to work around that.
Yes, sir.
All right.
Yes, sir.
Is there anything else from either side?
No,
No, Your Honor.
No? Okay, thank you. Bond will continue.
Thank you. Can I be excused?
Yes.
Thank you.
Pardon?
Do I need to do anything with bond conditions on that file?
Oh, counsel, on the Radcliffe matter, you didn't need any of the bond conditions changed, did you, Ms.
I
Rasser?
just want like, no contact with each victim.
Because I think victims may have been added, so I want to make sure.
No third-party contact.
All right, I have 6, 7. Anyway, it looks like I have 7 or 8 victims. So what I'm going to,
Send email the names to your staff to confirm they're in there, or could you send me the bond conditions and I'll confirm it?
sure, we can, why don't we send the bond condition? That's probably an easier way to do that. And then look at what needs to be amended. What we can do, counsel, is we'll try to do that by email if it's going to be something. I would add, of course, any alleged victims to the no contact. So I would probably do that in any event. But if there's something that needs to be added that looks something different, we will keep you apprised via email, give you an opportunity to respond to us regarding that before I make my decision. Fair enough?
Yes, sir.
All right.
Thank you.
Or does call the case, People State of Michigan versus Zachary Radcliffe. Counsel, state your appearances.
Good afternoon, Your Honor. Amy Reiser on behalf of the people.
James Thomas on behalf of Mr. Radcliffe, Your Honor.
All right. Mr. Thomas, this is the defendant's motion, so you may proceed.
Thank you, Your Honor.